Welcome, friends, for this Nani Palkhivala Law Club series. This series is related to now we are conducting today's episode on CPC 2 from Order 1 to Order 51. We try to complete, but whatever order we will complete in the prescribed time limit of today's, that means 1.5 hour or 1 hour and 15 minutes time, whatever it is possible, we will cover that. The purpose of this episode is purpose of this total webinar is to get continuously in mind struck on your mind, continuously strucking the section, the content of that section, so that after watching again and again, after hearing again and again, we can get idea in which chapter, what, in which section, what content is there, so that it can be get mastery on that particular subject to any lawyer, to any law student. It is the purpose behind this, specifically CPC 1, CPC 2, CPC 3, whatever episode will be there in our prescribed time limit. So friends, in CPC 1, we covered all sections from section 1 to section 158. That episode is already on YouTube. You can visit to our YouTube channel and you can have a look and you can enjoy that episode while you are exercising early in the morning, or while you are leisure time. In that particular time, you can enjoy all these things. Now, we are going to see what is the contents of order 1 to order 51. This is very huge size of these orders. Each order contains so many rules. Okay. And but what is related to the civil procedure code? How civil cases are conducted by civil courts, High Court, Supreme Court. But Supreme Court have a Supreme Court rules 2000. Supreme Court have Supreme Court rules 2013 also. So this is a somebody is requesting me to record this session. No need to record at your end. I am recording it, and my staff will upload it today or tomorrow. They maybe after day after tomorrow. Then you will get the link in the you will get it on YouTube. You can watch on YouTube. You can download any of my video from YouTube. So no need of recording. Otherwise, it will get me continuously disturbances while I am speaking with you. So friends, these orders from 1 to 51, we are now reading, observing, and we will see the contents of that order. Let me share the screen. Okay, I hope you are able to see screen. Okay. So friends, this is in CPC Schedule 1. All orders are in Schedule 1, the first schedule. Order 1, parties to suits. Rule 1, who may be joined as plaintiff. Rule 2, power of court to order separate trials. Rule 3, who may be joined as a defendant. Rule 3A, power to order separate trial where joinder of defendant may embarrass or delay. Rule 4, court may give judgment for or against one or more of joint parties. Rule 5, defendant need not be interested in all the relief claimed. Rule 6, joinder of parties liable on same contract. Rule 7, when plaintiff in doubt from whom redress is to be sought. Rule 8, one person may sue or depend on behalf of all in the same interest. Rule 8A, power of court to permit a person or body of a person to present opinion or to take part in the proceeding. Rule 9, misjoinder and non-joinder. Rule 10 is related to suit in name of wrong plaintiff. Rule 10A is related to power of court to request any pleader to address it. Rule 11, conduct of suit. Rule 12, appearance of one of several plaintiffs or defendants for others. Rule 13, objections as to non-joinder or misjoinder. Friends, whenever you apply to civil court for any application, when you are filing any application for getting any special request for making any special request or for taking any special privilege. So in that application, if you mention application under order so and so, rule so and so, so that will be very beneficial and it will get impact on the judges that lawyer is a learned. So try to mention whenever you file any application, try to mention section, rules, order, rules, everything. And sometimes you will find section also in CPC, section so and so of CPC, order so and so, and rule so and so, and I apply for this facility or that whatever your prayer is, you can mention in that. Now we are going towards order 2. Order 2 is related to frame of suit. Rule 1, frame of suit. Rule 2, suit to include the whole claim. Rule 3, joinder of cause of action. Rule 4, only certain claim to be joined for recovery of immovable property. Rule 5, claims by or against executor, administrator, or heir. Rule 6, power of court to order separate trials. Rule 7, objections as to misjoinder. Order 3, recognized agent and pleaders. Who can argue before the court? Who will be recognized agent? And what is provisions related to recognized agents and pleaders? It is given in order 3. Now we will see rule. Order 3, rule 1 is related to appearance, etc. may be in person by recognized agent or by pleader. Rule 2, recognized agents. Rule 3, service of process on recognized agent. Rule 4, appointment of pleader. Rule 5, service of process on pleader. Rule 6, agent to accept service. Then order 4, institution of suit. Institution of suit. Rule 1 is related to suit to be commenced by plaintiff. And rule 2 is registered of suit. Order 5 is related to issue and service of summons. This is a very big order. In that order, so many rules are there. Rule 1 to 8 is related to issue of summons. Order 5, rule 1, summons. Or rule 2 is related to copy of plaint annexed to summons. Rule 3, court may order defendant or plaintiff to appear in person. Rule 4, no party to be ordered to appear in person unless a resident within certain limits. Rule 5, summons to be either to settle issues or for final disposal. Rule 6, fixing day for appearance of dependent. Rule 7, summons to order dependent to produce document relied on by him. Rule 8, on issue of summons for final disposal, dependent to be directed to produce his witnesses. Rule 9 to 13, service of summons. We are in order 5. Don't forget that. In order 5, there are so many rules. We completed rule 1 to 9. Now we are going to see rule 9 to 30. Up to 8 we already completed. Rule 9, delivery of summons by court. Rule 9A contains summons given to plaintiff for service. That we always call dusty services like that. Rule 10, mode of service. Rule 11, service on several dependent. Rule 12, service to be dependent in person when practicable or on his agent. Rule 13, service on agent by whom dependent carries on business. Rule 14, service on agent in charge in suit for immovable property. Rule 15, where service may be on an adult member of dependent's family. Rule 16, persons served to sign acknowledgement. Rule 17, procedure when dependent refuses to accept service or cannot be found. Rule 18, endorsement of time and manner of or service. Rule 19, examination of serving officer. Rule 19A, it is repealed now. Rule 20, substituted service, it is repealed. Rule 20A, this is also repealed. This is repealed, but this is replaced by another way, or in subsection already it is covered. Because service of summons by post, it cannot be repeated. Already it is going on, but maybe this 20A is repealed, but somewhere it is given by our legislature authorities. Rule 21, service of summons where dependent reside within the jurisdiction of another court. Rule 22, service within a presidency town or summons issued by the court outside. Rule 23, duty of court to which summons is sent. Rule 24, service on dependent in prison. Rule 25, service where dependent reside out of India and has no agent. Rule 26, service in foreign territory through political agent or court. Rule 26A, summonses to be sent to officer of foreign countries. Rule 27, service of civil public officer or on service of railway company or local authority. Rule 28, services on soldier, sailors or airmen. Rule 29, duty of person to whom summons is delivered or sent for service. Rule 30, substitution of letter for summons. Now order 6, pleading generally. Rule 1, pleading. Rule 2, pleading to state material facts and not evidence. So pleading includes, friends, pleading includes plaint, written statement, rejoinder, counter again. So all these are including in plaints. So when we file any civil suit, so rule 2 is pleading to state material fact, not evidence. Rule 3, forms of pleading. Rule 4, particular to be given where necessary. Rule 5, further and better statement or particulars. It is repealed now. Rule 6, condition precedent. Rule 7, departure. Rule 8, denial of contract. Rule 9, effect of document to be stated. Rule 10, malice, knowledge, etc. Rule 11, notice. Rule 12, implied contract or relation. Rule 13, presumption of law. Rule 14, pleading to be signed. Rule 14A, address for service of notice. Rule 15, verification of pleadings. Rule 16, striking out pleadings. Rule 17, amendment of pleadings. Rule 18, failure to amend after order. Now, order 7, friends. Order 7 is related to plaint. Rule 1, particular to be contained in plaint. Rule 2 is related to money suits. Rule 3, where the subject matter to the suit is immobile property. Rule 4, when plaintiff sues as representative. Rule 5, dependent's interest and liability to be shown. Rule 6, grounds of exemption from limitation law. Rule 7, relief to be specifically started. Rule 8, relief founded on separate grounds. Rule 9, procedure on admitting plaint. Rule 10, return of plaint. Rule 10A, power of court to fix a date of appearance in the court where plaint is to be filed after its return. Rule 10B, power of appellate court to transfer suit to the proper court. Rule 11, rejection of plaint. Rule 12, procedure on rejection plaint. Rule 13, where rejection of plaint does not preclude presentation of a fresh plaint. Rule 14 to 18, documents relied on in plaint. Rule 14, production of document on which plaintiff sue or relied. Rule 15, statement in case of document not in plaintiff's possession or power. It is now repealed. Rule 16, suits on lost negotiable instruments. Rule 17, production of shop books. Rule 18, inadmissibility of document not produced when plaint failed. It is now repealed. Now, friends, order 8, written statement, set off and counterclaim. Rule 1, written statement. Rule 1A, duty of dependent to produce document upon when relief is claimed or relief upon by him. Rule 2, new facts must be specifically pleaded. Rule 3, denial to be specific. Rule 4, evasive denial. Rule 5, specific denial. Rule 6, particulars of setup to be given in written statement. Rule 6A, counterclaim by defendant. Rule 6B, counterclaim to be stated. Rule 6C, exclusion of counterclaim. Rule 6D, effect of discontinuance of suit. Rule 6E, default of plaintiff to reply to counterclaim. Rule 6F, relief to defendant where counterclaim succeeds. Rule 6G, rule related to written statement to apply. Rule 7, defense or setup founded upon separate grounds. Rule 8, new ground of defense. Rule 8A, duty of defendant to produce document upon which relief is claimed by him. Rule 9, subsequent pleadings. Rule 10, procedure when party fails to present written statement called for by court. Now order 9. Friends, like this, like CPC, we will cover other laws also. Important 6 basis laws are there. We must know each and every section, each and every order, each and every rule, what is contained. So these are our basic granth we can call. CRPC, CPC, IPC, Evidence Act, Limitation Act, Constitution of India, all our practice is depend upon this. But when you are practicing in High Court and Supreme Court, that time High Court procedure, you have to follow additional to this CRPC, CPC. And when you are in Apex Court, that time Supreme Court rules or Supreme Court rules and procedure 2017 and Supreme Court rules 2013, you have to follow. I'm practicing Supreme Court of India. So we don't now see each and every rule say, but when appeal comes to related to the civil matter and related to properly not following the procedure, that time we have to study all this matter. And in our Supreme Court specifically, we have to study all the document related to trial court, that means civil court, after civil court, then district court, then high court, after high court, Supreme Court. We have to study all these documents. So everywhere, whether you are practicing a tribunal, whether you are practicing in civil court, whether you are practicing in criminal court, whether you are practicing high court, Supreme Court, these 6-7 laws are very, very important. So this is my endeavor to create a audio visio, some videos or some episodes. So in leisure time, we can repeat it again and again. So friends, order 9, appearance of parties and consequence of non-appearance. Rule 1, parties to appear on day fixed in summons for dependent to appear and answer. Rule 2, dismissal of suit where summons not served in consequence of plaintiff's failure to pay the cost. Rule 3, where neither party appears, suit to be dismissed. Rule 4, plaintiff may bring fresh suit or court may restore suit to file. Rule 5, dismissal of suit where plaintiff after summon written unserved fail for 7 days to apply for fresh summons. Rule 6, procedure when only plaintiff appears. Rule 7, procedure where dependent appears on day of adjourned hearing and assign good cause of previous non-appearance. Rule 8, procedure where dependent only appears. Rule 9, decree against plaintiff by default bar fresh suit. Rule 10, procedure when party fails to present a written statement called for by court. Rule 11, procedure in case of non-attendance of one or more several dependent. Rule 12, consequence of non-attendance without sufficient cause shown of parties ordered to appear in person. Rule 13 to 14, setting aside decree ex parte. Rule 13, setting aside decree ex parte against defendant. Rule 14, non-decree to be set aside without notice to opposite party. Order 10, examination of the parties by the court. Rule 1, ascertainment whether allegation in pleadings are admitted or denied. Rule 1A, direction of the court to opt for any one mode of alternative dispute resolution. Rule 1B, appearance before the conciliatory forum or authority. Rule 1C, appearance before the court consequent to the failure of efforts of conciliation. So, conciliation is there. Conciliation departments are there in High Court, Supreme Court. We can opt for that. In the marriage petitions, this is required. And in Arbitration Conciliation Act also, conciliation provision is there. Try to conciliate and try to end your dispute outside the court. That is the purpose of this. But when in court also, but efforts of conciliation should be there. Rule 2, oral examination of party or companion of party. Rule 3, substance of examination to be written. Rule 4, consequence of refusal or inability of pleader to answer. Don't expect any explanation of each and every rules here, because endeavor of this episode is to see only rule, order, rule, and what is its content. Okay, my separate videos, so many separate videos, so many separate webinars are on different topics, different laws. You can watch on regularly. You can watch. You can subscribe that channel. Jayprakash Somani channel's name is Jay Somani 64, I think. And you can go there and you can see that so many videos, more than 300 videos of mine are there. So many of them Hindi also, many of them are in English also. So you can see that. For example, and in future also we will create a separate videos on like that res judicata, section 11 of CPC. Only on that we will create a separate video. So important sections, important topic, we can create a separate videos for understanding of that. But endeavor of this particular session is to see the content of each and every order, rule, section like that. So friends, order 11 now, discovery and inspection. Rule 1, discovery by interrogatories. Rule 2, particular interrogatories to be submitted. Rule 3, cost of interrogatories. Rule 4, form of interrogatories. Rule 5, corporations. Rule 6, objections to interrogatories by answer. Rule 7, setting aside and striking out interrogatories. Rule 8, affidavit in answer filing. Rule 9, form of affidavit in answer. Rule 10, no exception to be taken. Rule 11, order to answer or answer further. Rule 12, application for discovery of document. Rule 13, affidavit of documents. Rule 14, production of document. Rule 15, inspection of documents referred to be in pleadings or affidavits. Rule 16, notice to produce. Rule 17, time for inspection when notice given. Rule 18, order for inspection. Rule 19, verified copies. Rule 20, premature discovery. Rule 21, non-compliance with order for discovery. Rule 22, using answers to be interrogatories at trial. Rule 23, order to apply to minors. Now order 12, admissions. Rule 1, notice of admission of case. Rule 2, notice to admit documents. Rule 2A, documents to be deemed to be admitted if not denied after service of notice to admit documents. Rule 3, form of notice. Rule 3A, power of court to record admission. Rule 4, notice to admit facts. Rule 5, form of admissions. Rule 6, judgment on admissions. Rule 7, affidavit of signature. Rule 8, notice to produce document. Rule 9, costs. Now, Order 13, production, impounding, and return of documents. Rule 1, original documents to be produced at or before the settlement of issues. Rule 2, effect of non-production of documents. Rule 3, rejection of irrelevant or inadmissible documents. Rule 4, endorsement on documents admitted in evidence. Rule 5, endorsement of copies of admitted entries in books, accounts, and records. Rule 6, endorsement on document rejected as inadmissible in evidence. Rule 7, recording of admitted and return of rejected documents. Rule 8, court may order any document to be impounded. Rule 9, return of admitted documents. Rule 10, court may send for papers from its own record or from other courts. Rule 11, provision as to documents applied to material objects. Now Order 12, settlement of issues and determination of suit on issues of law or on issues of agreed upon. Rule 1, framing of issues. Rule 2, court to pronounce judgment on all issues. Rule 3, material from which issues may be framed. Rule 4, court may examine witnesses or documents before framing issues. Rule 5, power to amend and striking out issues. Rule 6, question of fact or law may by agreement be stated in the form of issues. Rule 7, court, if satisfied that agreement was executed in good faith, may pronounce judgment. Order 15, disposal of suit at the first hearing. Rule 1, parties not at issue. Rule 2, one of several dependent not at issue. Rule 3, parties at issue. Rule 4, failure to produce evidence. Now Order 16, summoning and attendance of witnesses. Rule 1, list of witnesses and summons to witnesses. Rule 1A, production of witnesses without summons. Rule 2, expenses of witnesses to be paid into court on applying for summons. Rule 3, tender of expenses to witnesses. Rule 4, produce where insufficient sum paid in. Procedure where insufficient sum paid in. Rule 5, time, place, purpose of attendance to be specified in summons. Rule 6, summons to produce document. Rule 7, power to required persons present in court to give evidence or produce documents. Rule 7A, summons given to party for service. Rule 8, summons how served. Rule 9, time for serving summons. Rule 10, procedure where witnesses fails to comply with summons. Rule 11, if witnesses appears, attachment may be withdrawn. Rule 12, procedure if witnesses fails to appear. Rule 13, mode of attachment. Rule 14, court may of its own accord summons as witnesses stranger in strangers to suit. Rule 15, duty of persons summons to give evidence or produce document. Rule 16, when they may depart. Rule 17, application of Rule 10 to 13. Rule 18, procedure where witnesses apprehended cannot given evidence or produce document. Rule 19, no witnesses to be ordered to be attending in person unless resident within certain limits. Rule 20, consequence of refusal of party to give evidence when called by the court. Rule 21, rules as to witness to party to apply to party summons. Rule 16A, attendance of order, so not rule, now separate order is this, order 16A, attendance of witnesses confined or detained in person in prisons. Attendance of witnesses confined or detained in prisons. Rule 1, definitions. Rule 2, power to require attendance of prisoners to give evidence. Rule 3, expenses to be paid into court. Rule 4, power of state government to exclude certain persons from the operation of Rule 2. Rule 5, officer in charge of prison to abstain from carrying out order in certain cases. Rule 6, prisoners to be brought to the court in custody. Rule 7, power to issue commission to examination of witnesses in prison. Order 17, adjournments. Rule 1, court may grant time and adjourn hearing. Rule 2, procedure if parties fail to appear on day fixed. Rule 3, court may proceed notwithstanding either party fails to produce evidence, etc. Rule 18, hearing of suit and examination of witnesses. Rule 1, right to begin. Rule 2, statement and production of evidence. Rule 3, evidence where several issues. Rule 3A, party to appear before other witnesses. Rule 4, recording of evidence. Rule 5, how evidence shall be taken in appellable cases. Rule 6, when disposition to be interrupted. Rule 7, evidence under section 138. Rule 8, memorandum when evidence not taken down by judge. Rule 9, when evidence may be taken in English. Rule 10, any particular question and answer may be taken down. Rule 11, question objected to and allowed by court. Rule 12, remark on demand hour of witnesses. Remark on demand hour of witnesses. Rule 13, memorandum of evidence in unappellable cases. Rule 14, judge unable to make such memorandum to record reason of his inability. It is repealed now. Rule 15, power to deal with evidence when evidence taken before another judge. This is related to power to deal with evidence taken before another judge. Rule 16, power to examine witness immediately. Rule 17, court may recall and examine witnesses. Rule 17A, production of witnesses not previously known or which could not be produced despite due diligence. Rule 18, power of court to inspect. Rule 19, power to get statements recorded on commission. Order 19, affidavits. Rule 1, power to order any point to be proved by affidavit. Rule 2, power to order attendance of dependent for cross-examination. Rule 3, matter to which affidavit shall be confined. Order 20, judgment and decree. Rule 1, judgment when pronounced. Rule 2, power to pronounce judgment written by judge predecessor. Rule 3, judgment to be signed. Rule 4, judgment of small cause courts. Rule 5, court to state its decision on each issue. Rule 5A, court to inform parties as to where an appeal lies in cases where parties are not presented by the pleaders. Specifically, judgment and decree, all the students or all the lawyers who wish to go in judiciary as a judges, as a JMFC or as a civil judges or as a district judges or ADJ like that. So for them, this procedure for writing judgment, decree is very important, friends. My best wishes to all of you, those who desire and who are working hard on that, they will get success and gradually come to my court as a judge in Apex Court, Supreme Court of India, and give me chance to argue before you, your lordship. Rule 6, we are in order, we are order 20. Rule 6, contents of decree. Rule 6A, preparation of decree. Rule 6B, copies of judgment when to be made available. Rule 7, date of decree. Rule 8, procedure where judge has vacated officer before signing decree. Rule 9, decree for recovery of immovable property. Rule 10, decree of delivery of immovable property. Rule 11, decree may direct payment by installments. Rule 12, decree for possession and means profit. Rule 12A, decree for specific performance of contract for the sale or lease of immovable property. Rule 13, decree in administration suit. Rule 14, decree in preemption suit. Rule 15, decree in suit for dissolution of partnership. Rule 16, decree in suit for account between principal and agent. Rule 17, special direction as to account. Rule 18, decree in suit for partition of property or separate possession of a share therein. Rule 19, decree when set-off or counterclaim is allowed. Rule 20, certified copies of judgment and decree to be furnished. Order 20A, costs. Rule 1, provision related to certain terms. Rule 2, cost to be awarded in accordance with the rules made by High Court. Order 21, execution of decree and orders. Rule 1 to 2, payment under decree. Rule 1, modes of paying money under decree. Rule 2, payment out of court to decree holders. Rule 3 to 9, courts executing decrees. Rule 3, land situated in more than one jurisdiction. Rule 4, transfer of court of small causes. Rule 5, mode of transfer. Rule 6, procedure where court desired that its own decree shall be executed by another court. Rule 7, court receiving copies of decree, etc. to file same without proof. Rule 8, execution of decree or order by court to which it is sent. Rule 9, execution by High Court of decree transferred by another court. Rule 10 to 23, application for execution. Rule 10, application for execution. Rule 11, oral application. Rule 11A, application for arrest to state ground. Rule 12, application for attachment of movable property not in judgment debtor's possession. Rule 13, application for attachment of immovable property to contain certain particulars. Rule 14, power to require certified extract from collectors registered in certain cases. Rule 16, application for execution by joint decree holders. Rule 16, application for execution by transferee of decree. Rule 17, procedure on receiving application for execution of decree. Rule 18, execution in case of cross decrees. Rule 19, execution in case of cross claims under same decree. Rule 20, cross decrees, cross claim or in mortgage suits. Rule 21, simultaneous execution. Rule 22, notice to show cause against execution in certain cases. Rule 22A, sale not to be set aside on the death of the judgment debtor before the sale out after the service of the proclaim of sale. Rule 23, procedure after issue notice. Rule 24 to 25, process of execution. Rule 24, process of execution. Rule 25, endorsement of process. Rule 26 to 29 is related to stay of execution. Rule 26, when court may stay execution. Rule 27, liability of judgment debtor discharged. Rule 28, order of court which passes decree or appellate court to be binding upon the court applied to. Rule 29, stay of execution pending suit between decree holder and judgment debtors. Rule 30 to 36, mode of execution. Rule 30, decree for payment of money. Rule 31, decree for specific movable property. Rule 32, decree of a specific performance for restitution of conjugal rights or for an injunction. Rule 33, discretion of court in executing decree for restitution of conjugal right. Rule 34, decree of execution of document or endorsement of negotiable instruments. Rule 35, decree for immobile property. Rule 36, decree for delivery of immobile property when in occupancy of tenant. Rule 37 to 40, arrest and detention in the civil prison. Rule 37, discretionary power to permit judgment debtor to show cause against detention in prison. Rule 38, warrant for arrest to direct judgment debtor to be brought up. Rule 39, substance allowance. Rule 40, proceedings on appearance of judgment debtor in obedience to notice or after arrest. Rule 41 to 57, attachment of property. Rule 41, examination of judgment debtors as on his proprietary. Rule 42, attachment in case of decree for rent or means profit or other matter, amount of which to be subsequently determined. Rule 43, attachment of movable property of movable property other than agriculture produce in possession of the judgment debtor. Rule 43A, custody of movable property. Rule 44, attachment of agriculture produce. Rule 45, provision as to agriculture produce under attachment. Rule 46, attachment of debt, share and other property not in possession of judgment debtors. Rule 46A, notice to garnishee. Rules 46B, order against garnishee. Rule 46C, trial of dispute questions. Rule 46D, procedure when debt belongs to third person. Rule 46E, order as regard third person. Rule 46F, payment by garnishee to be valid discharge. Rule 46G, cost. Rule 46H, appeals. Rule 46I, application to negotiable instruments. Rule 47, attachment of share in movables. Rule 48, attachment of salary and allowances of servant of government or railway company or local authorities. Rule 48A, attachment of salary or allowances of private employees. Rule 49, attachment of partnership properties. Rule 50, execution of decree against firm. Rule 51, attachment of negotiable instruments. Rule 52, attachment of property in custody of court or public officer. Rule 53, attachment of decrees. Rule 54, attachment of immovable property. Rule 55, removal of attachment after satisfaction of decree. Rule 56, order for payment of fine or currency notes to party entitled under decree. Order 57, determination of attachment. Rule 58 to 63, adjudication of claim and objection. Adjudication of claim and objection. Rule 58, adjudication of claim to or objection to attachment of property. Rule 59, stay of sale. Rule 60 to 63, omitted. Rule 64, 73 to 73, sale generally. Rule 64, power to order property attached to be sold and proceed to be paid to person entitled. Rule 65, sales by whom, conducted and how made. Rule 66, proclamation of sales by public auction. Rule 67, mode of making proclamation. Rule 68, time of sale. Rule 69, adjournment or stoppage of sale. Rule 70 is repealed. Rule 71, defaulting purchaser answerable for loss or resale. Rule 72, decree holder not to bid for or buy property without permission. Rule 72A, mortgage not to be bid at sale without the leave of the court. Rule 73, restriction on bidding or purchase by order by officers. Rule 74 to 81, sale of movable property. Rule 74, sale of agriculture produce. Rule 75, specific provision related to growing crops. Rule 76, negotiable instrument and share in corporation. Rule 77, sale by public auction. Rule 78, irregularity not to be vitiate sales, but any person injured may sue. Rule 79, delivery of movable property, debt and share. Rule 80, transfer of negotiable instruments and shares. Rule 81, vesting order in case of other property. Rule 82 to 96, sale of immovable property. Rule 82, what courts may order sales. Rule 82, postponement of sales to enable judgment debtor to raise amount of decree. Rule 84, deposit by purchaser and resale on default. Rule 85, time for payment in full of purchase money. Rule 86, procedure in default of payment. Rule 87, notification on resale. Rule 87, already we covered notification on resale. Rule 88, bid of co-share to have preference. Rule 89, application to set aside sale on deposit. Rule 90, application to set aside on ground of irregularity or fraud. Rule 19, application by purchaser to set aside sale on ground of judgment debtor having no sellable interest. Rule 92, sale when to become absolute or be set aside. Rule 93, return of purchase money in certain cases. Rule 94, certificate to purchaser. Rule 95, delivery of property in occupancy of judgment debtor. Rule 96, delivery of property in occupancy of tenant. Rule 97 to 106, resistance of delivery of possession to decree holder or purchaser. Rule 97, resistance or obstructions to possession of immovable property. Rule 98, orders after adjudication. Rule 99, dispossession by decree holder or purchaser. Rule 100, order to be passed upon application complying of disposition. Order 101, question to be determined. Rule 102, not order, Rule 101, question to be determined. Rule 102, rule not applicable to transferee pendant light. Rule 103, order to be treated as a decree. Rule 104, order under Rule 101 or Rule 103 to be subject to be result or pending suit. Rule 105, hearing of application. Rule 106, setting aside order passed ex parte, etc. Friends, we covered order 21 and order 22 onwards till order 51 we will cover in part 3. So this is the end of CPC part 2. Friends, this is very exhaustive procedure, but somehow we have to compile that, at least content we should understand, and whenever we require, that time we can go in depth. Go in depth, see detailed provision, see the commentary books, come to the conclusion, then make the point properly, and then plead before, properly argue before your respected court. Well, that particular court may be trial court or maybe High Court or Supreme Court. But when you are arguing with proper order, proper rules, proper sections, proper citations, and your argument should have a proper sequence, that time judges like your argument. They enjoyed their judging. Otherwise, some people are arguing in a such a way, judges feels this is a punishment for us to listen these arguments. But some lawyers argue in such a way Judges feels they are enjoying their justice. Give that feel to judges, friends. So enjoy your lawyership. And for that purpose, perfect drafting, perfect uh, perfect getting the points of arguments, proper research for citation, then proper sequence of argument, and then proper argument in the courts. That is required. And you can watch my one video on YouTube, argue in English fluently and confidently. So I'm conducting that course for those who are unable to argue in English properly, for those who are able to argue in English, but they don't have the confidence while they are standing before the court, before the judges. They get some type of botheration like that. So for such people also, that course is very nice. You can watch that course is in 16 part, but part 2 we keep open to watch for anybody. So you can watch that, and if you think so to join that, then you can join that. In that particular course, I am giving you the test of all type of cases, all type of cases. Army matters, property matters, insolvency matters, income tax matters, matrimonial matter, transfer petition, SLPs, statutory appeals, all type of matters I am giving test. Not only knowledge, but drafting properly, arguing skill, then argument on behalf of petitioner, argument on behalf of respondent, all things. Just watch that part 2, which is open on YouTube to watch for anybody. But part 1, part 3, part 4, part 5 are hidden because that is a course. So whoever is apply for that course, then he will get that 3 things. Now admission for Argue in English batch is now closed. Regular my batch is running now. After this program, I'm conducting that program, part 7 of AEFC. That means Argue in English fluently and confidently, part 7. And in each part, we are giving a best videos also. We are giving the proper instructions. If any lawyer follow that instruction which is given in part 1 to part 6 and implement that thoroughly within that 2 months time, 2 months course is that, I definitely give you guarantee he will become a good advocate, leading advocate of our country. Yes, my motto behind that course is to create a lawyer like a Nani Palkhivala, to create a lawyer like a live legends of senior lawyers in Supreme Court, like so many lawyers in Supreme Court, like judges of Supreme Court, like judges of high courts, how the judges are. So we are giving videos, we are giving so many times. My main motto is not to conduct that course, not to earn money, because we are getting so much handsome money than that course in our regular practice here. But motto is to create an excellent arguing counsel. And so many ideas in my mind, but as age permits, as my work permits, so I will implement. But some of workshops, some of webinar, I will conduct it at midnight also. At midnight also. Somebody will say, how crazy that person is. He's mad. No, friends. But due to heavy practice of Supreme Court, I have 12 juniors. Out of that 12 juniors, 7 are AORs. But even though huge load of practice, all India's all type of matters we are handling, friends. And whatever we are giving you in that particular AEFC course, Argue in English fluently and confidently course, that is which matter we have drafted, we have argued, we have succeeded, we have shown you. So practical touch is there, friends. So whether you are from rural area, whether you are from mother tongue background like me, I'm from rural area, from Maharashtra. My mother tongue is Marathi, and I since till the 10th standard we are thoroughly in Marathi medium. But after that, gradually we took BCom, we completed in English medium, then we completed law in English medium. But don't bother about your background, bother about your future. What you want. Do you want to work at international level? Yes, it is possible, friends. But that for that purpose, you have to strive hard. So I will take some webinars in midnight also, in early morning also. That is called Brahma Muhurta, like that. But many of my webinar, many of my seminars will be in adequate good time. That means always at 7 p.m. So you can enjoy that. So join Nani Palkhivala Law Club, official group 1, 2. So you will get their regular circular. Thank you. Thank you very much, friends. Have a nice day.